Okay, we're here on the State of Florida versus Nicholas Cruz. This is case number 18-14129. Will the parties who are going to be appearing for both sides and arguing for both sides please announce for the record before we get started?
Maria Schneider on behalf of the State of Florida.
David Wheeler on behalf of Nicholas Cruz.
Okay, we're here today for the hearing on the state's motion for a subpoena ducis tecum for an order authorizing the issuance of a subpoena for the purposes of medical records, as well as the defendant's objection to that request.
Yes.
Schneider?
Yes, Your Honor. Your Honor, the state's notice of intent to issue a subpoena ducis tecum for the defendant's medical records regarding the care and treatment received as a result of the incident of November 13, 2018, was first issued to the defense on June 17th of 2020. The defense objected on June 21st of 2020. The state did not, at that point, follow through with filing any kind of a hearing before the court. I would point out to the court that the courthouse was closed since March of 2020. June would have been, just shortly thereafter, and there was a whole lot going on at the time. During the later part of 2020, the defense continued taking depositions in this case. Throughout those depositions, there were additional facts that came about that the state wasn't aware, I wasn't aware of. The defense listed a number of witnesses, Colonel James Reyes, who had not been listed by the state, and some others. And during deposition, they began to develop a defense that includes, apparently, the fact that the defendant and the deputy in question had had issues, had had problems prior to November 13th of 2018. Sometime thereafter, February 15th, 2021, a new notice of intent to issue a subpoena ducis tecum was issued by the state, to which the defense objected. I note that I bring to the court's attention the fact that the notice of intent to issue a subpoena ducis tecum before the court right now is seeking two things.
Okay.
It's seeking the records of any care and treatment provided to the defendant as a result of the incident of November 13, 2018.
Okay.
And in addition, which is not something that was sought originally in the notice to issue a subpoena ducis tecum, as a result of the depositions and the facts that have been developed by the defense, we are now also seeking any kind of care and treatment, medical, these are not psychological records, this is strictly medical, any medical care and treatment that the defendant received from February 14th of 2018 when he was first arrested until November 13th of 2018 that might reflect issues as they are bringing up with this particular deputy, because allegedly, it had been an ongoing problem between them prior to that. So the notice before the court today is not the same as the original notice that the state gave of intent to issue a subpoena ducis tecum. We are seeking two different sets of records, or records for two different times. We are before you now on their objection, basically. The defense argues that there is insufficient nexus between the jail medical records and this criminal prosecution. They also argue that the doctrine of laches prohibits the state from seeking these records.
Just 1 second.
Sure.
Like that. I know it has. Sorry about that.
During the deposition, by the way, I'd point out to the court that the defense in this case never set for deposition the medical personnel. However, in the murder case, they did set the medical personnel in this case down for deposition. During those depositions, the depositions specifically of Julio Fuertes, Javon Nash, and Vicki McDowell, those are three individuals that worked at the jail at the time. They were part of the medical team. they indicated that they weren't able to answer questions regarding the specific care and treatment provided to the defendant without the records. You know, it's been a long time, they see a lot of patients, and they weren't able to give us any information without the records. So those witnesses weren't deposed until much after the original notice of intent to issue a subpoena ducis tecum that the state provided. Anyways, so the defense is arguing that there's insufficient nexus between the jail records that we are seeking and the criminal prosecution, and they're arguing that the doctrine of laches should prohibit the state from seeking the records. I'm going to take them one at a time. First of all, as to whether there is a sufficient nexus between the jail medical records and the criminal prosecution. Your Honor, I would ask the court to take judicial notice first of the probable cause affidavit in this case. I'm going to hand the court a packet that contains the probable cause affidavit and a number of cases that I was referring to. I've provided a copy to the defense already. I'd also like, Your Honor, to play the video of the incident, as that is the basis. You know, there was there's a physical confrontation between two people, and there is definitely the potential for injuries, which is the nexus that we are arguing to the court exists. So I have the video queued up if the court would like to see it. I think that the images clearly establish the nexus between, you know, the incident and the medical records. So that's the first thing that I'd like to do.
Is there any objection?
No, Judge.
Okay. Are you going to admit that into evidence?
Yes,
for
I am.
purposes of the hearing?
For
Is there any
purposes of this
objection
hearing.
to that?
Judge, I may have a motion to seal afterwards, but that's
Okay, but for purposes of the evidentiary hearing before the court today for consideration, there's no objection to the state admitting what will be marked as state's composite exhibit 1, or not composite exhibit, but digital exhibit 1?
And Judge, I don't know if the state intends to play the court or if it's just hoping to publish it to the rest of the people that are here.
I'm assuming it's for me because I've not seen it.
Right, Judge.
So I'll need to step down or put it aside because I can't see it from here. All right.
I can feel
Can you turn
it.
it?
Oh, you can turn it?
No, you don't. No.
Okay.
I mean,
I mean, the whole thing will, so we've done the whole thing.
it's okay like that?
I can see it. Is there audio or?
No, there's no audio.
Judge, can we fast forward it to the actual incident? This is
There's a lot of walking around first. Do you want to try?
Sure, both sides agree that's fine.
It is 50. 55.
fast forward this?
We fast forward about 4 minutes. You can turn it off. As Your Honor can see from the video, and you can deduce from the probable cause affidavit that I've handed to the court, there is a physical altercation. There is obviously, there's hitting that goes on between the two individuals. There's hitting against the floor. There's hitting against the table. So we feel that whether the defendant received injuries as a result of that is relevant to this case. Additionally, Your Honor, during the depositions that were taken, as I said before, witnesses that were either listed by the defense or the depositions of the medical personnel, whether in the other case, indicate that the defense here in this case looks like it's going to be that that this was provoked, that this was a provoked attack because there have been confrontations or issues between the deputy and the defendant prior to this incident. And obviously, if there had been any injuries suffered by the defendant or any kind of condition that he was complaining of, it should have been reported to the medical personnel at the jail. So that is why we are seeking the additional records. So it's a two-part request of the two records. Your Honor, the standard that applies to the issuance of the subpoena ducis tecum is whether there is a compelling state interest in obtaining the records. And I cite to State versus Johnson, which is located at 814 Southern 2nd 390. It's a Florida Supreme Court case from 2002. It is sufficient for the state to demonstrate that there is a reasonable founded suspicion that the requested medical records contain information relevant to the ongoing prosecution. Well, I think the images that you just saw, establish that there is clearly, there are clearly going to be records in the defendant's medical file that reflect what kind of care and treatment he received after the incident. And in fact, we did take depositions that confirmed that he did receive care and treatment. Again, the witnesses were not able to tell us exactly what it was because they didn't have a recollection without their records. In State versus Taiwanese, which is located at 46 Florida Law Weekly, D1216, it's a 4th DCA case from this year, and Guardado versus State, which is located at 61 Southern 3rd, 1210, also a 4th DCA case from 2011. They established that when we can make when we have reasonable founded suspicion that there is going to be evidence in those records, in medical records, we are entitled to get them. There's a clear connection between the illegal activity, the attack on the deputy, and any injuries or care and treatment the defendant might have received as a result thereof. Control and prosecution of criminal activity is a compelling state interest, going back to Johnson that I cited previously to the court. And the records from before the date of the incident are relevant, again, to address the allegations that are being made by the defense that the deputy in question and the defendant had confrontations in the past prior to the incident. So given the clear connection between the illegal activity and the defendant whose records are being sought, we feel that our request for issuance of a subpoena ducis tecum is founded in suspicion, in reasonable suspicion, and should be granted. As to the doctrine of laches, that was an interesting one. Generally, laches is a doctrine asserted as a defense which requires proof of two things. One, lack of diligence by a party against whom the defense is asserted, and two, prejudice to the party asserting the defense. And it is up to that party, the party is asserting the defense, they have the burden of proving prejudice. I would cite to the court McCrae versus State, which is located at 699 Southern 2nd, 1366. It's an equitable defense, and its applicability depends on the circumstances of each case. Delay alone does not constitute laches. The burden is on the party who asserts that doctrine to prove prejudice. I also cite to Tickton versus Kieran, which I provided to the court. That's located at 807 Southern 2nd, 659. That's a Florida 3rd DCA case from 2002. The defense is asserting that the delay of 8 months between the state's first seeking to issue a subpoena ducis tecum for the records and the second filing in February of this year amounts to laches, and we would argue to the court that it does not. In the cases where the doctrine of laches has been found, there's usually been a delay of like years, and the prejudice is usually that there is evidence that's been destroyed. And what's the prejudice here? We're still in the midst of preparing this case for trial. They allege in their motion in opposition to our motion for a subpoena to tecum that they had formulated a defense and now they have to formulate a new one. Well, you know, that happens all the time when you're preparing a case for trial. And I don't think that that's the kind of prejudice, if any, that should preclude the state from getting the medical records, which are material in this case and which we should be entitled to get. And that basically is our argument.
Okay.
Thanks, Judge.
Mr. Miller?
If I can respond. Judge, a patient's medical records are protected by the Florida Constitution in Article 1, Section 23, as well as the Health Insurance Portability and Accountability Act, or HIPAA, of 1996. The state does have the burden of showing there is some sort of nexus of relevancy between their ongoing investigation and the records that are being requested. What's interesting to note, Judge, is that the state's investigation in this case stopped the day Detective O'Malley went to the jail, received the truncated video that was played for the court, and took some pictures. Judge, if I can make this a court exhibit, if I may approach.
Sure.
Judge, I have what's previously marked as defense composite 1 and 2.
Okay.
Judge,
What do you want to start with?
I think number 1 is Sergeant Beltran.
This is number 1.
That's Mr. Cruz.
And this is number 2.
Correct. So, Judge, what we have is
So which one are you starting with?
we'll start with 2.
Okay.
Judge, we have the composite number 2 showing Mr. Beltran's injuries sustained during the altercation with a client. If the court would like to thumb through those.
Sure. And is there any objection to the court receiving the defense composite exhibit 1 and 2 for purposes of this hearing?
No objection.
It will be received as defense composite exhibit 1 and 2. For the record, defense composite exhibit 1 contains 5 photographs depicting Mr. Cruz indicated. Is that correct?
That's correct, Judge.
And then defense composite exhibit 2 contains also 5 photographs depicting what you've indicated as Sergeant Beltran.
That's
Is that
correct.
Okay.
So, Judge, what the defense has handed the court depicts the breadth and extent of the injuries sustained by the 2 combatants. Pardon?
2 defendants.
Combatants.
Combatants.
Judge, the reason that I highlight that is that what the state has to show is a compelling state interest. Certainly, the state has indicated previously, in May of 2019, that it was aware that the defendant has seen a doctor and that an EKG was performed. I don't know how they received that information, Judge, to be honest with the court. I don't know how they received it. I've included a copy of that transcript, and I've given it to the court this morning along with the state.
I'm sorry, the transcript of?
That was May 28th, 2019.
I can direct the court to the pages.
I think I'm starting on page 40, if I'm not mistaken.
Page 40, 40?
40.
Correct, Your Honor, 40, 41, and 41.
I think there might have been, okay,
Judge, and that's the last full paragraph on the page.
40 and 41, starting on line 25 of page 40?
Line 21.
Line 21.
So what I mean to say to the court is that there is no compelling state interest for the state to delve into my client's private medical records. Being that it already has the evidence the court has seen in video, the court has seen the photographs in possession of the state that was provided in discovery. Second to that, Judge, the state has not once but twice announced ready for trial, and that was on December 10th, 2019, which I provided a court a transcript of, and that's page 30, line 25, as well as on February 21st, 2019, which I've also provided the court a transcript of on page 7, line 23. So how compelling can the state's interest be in receiving these records on a case that they've indicated they are ready for trial?
Can I respond?
Are you finished, Mr. Weaver?
No, Judge.
Okay.
Sorry.
Sorry, the pause fooled me.
It's a long, pregnant pause. What's the new hook in the state's motion, Judge, is that they are now seeking records going back to the date of his first arrest, February 14th, 2018. And what I can only describe as a fishing expedition in the hopes that the state can find some sort of incriminating statement to medical personnel or some sort of appearance of demeanor that they would be noted in the medical records. Just there was absolutely zero relevance whatsoever to an event that occurs 9 months after the fact. At the very least, the defense would concede that the records from the day of the incident may be relevant. But we would ask the court to perform an in-camera inspection of these records to see if there is any relevance before releasing them to the state.
And you're speaking solely of the records from the date of the incident or a day later?
Correct.
Okay.
And just to clarify, the reason that the depositions of the medical personnel were taken in the homicide case is that the state listed them as potential witnesses in a homicide case. So we have that ability to take the depositions of them under that case number. And rightfully so, they don't have any independent recollection of any type of service they performed years after the event. Finally, Judge, I see the court's stopped writing. The state first made the request to seek these records in writing through a motion on that May of 2019 hearing date that I just indicated to the court. I'm not sure if the state and Mr. Burke had previous conversations prior to that. I wasn't privy to those. But the issue is they didn't file their motion until April of this year. So they've been just kind of gestating on it or digesting their ability to go forward on it. That's why we bring forward the laches doctrine. We would indicate that there is not only delay in that particular instance, but we are prejudiced as a party because we now have to go back and maybe redepose witnesses based upon evidence that the court decides to release today.
Okay.
That's it.
Okay. All right. Your Honor, I would cite to State v. Johnson that I provided to the court and gave the cite and to the record previously. That case specifically says that control and prosecution of criminal activity is a compelling state interest. And obviously, we are in the midst of prosecuting this case, which involves criminal activity. Your Honor, the medical personnel were not deposed in the original case, in this case. They were only deposed on the homicide case, and these people were listed in the homicide case because obviously this case is a predicate for the death penalty. So, in an abundance of caution, they were listed so the defense would be on notice of that. None of that has anything to do with the fact that, and neither does the photographs that counsel showed you, obviate the right of the state to get the medical records. We all know that there can be internal injuries. We all know that people can suffer injuries that are not reflected on the skin. So we need to have the medical records so that we can know the exact extent of the injuries. And we need to have the prior medical records because it is the defense that has put those at issue. They are the ones who listed all these additional witnesses, and in their depositions, these witnesses discussed the fact that apparently the public defender's office had called the jail and had said that the defendant didn't want to be supervised by this particular deputy. So they're the ones that have put this at issue, and that's why we're following up on that. And I think we're entitled to. We don't have to stop investigating a case just because we've filed it. Cases evolve as the investigation continues, and that's what we're doing. So we do believe that there is a clear nexus both between the record, the criminal activity, and the records that we're seeking for the care and treatment as a result of the injury the day of. So it's not just the records of the day of, it's care and treatment of the day of. I don't know if he needed to go back a week later or 2 weeks later or whatever it is. I guess we'll find out. But anything that reflects care and treatment as a result of the incident of the 13th, November 13th of 2018, and because of the defense placing the issue of possible prior contact between the defendant and the deputy at issue, we believe that we now have a nexus, a sufficient nexus for requesting the medical records of any care and treatment that he might have received prior to November 13th of 2018.
So I think I misspoke when I asked you, the defense, if you said you are stipulating that there's relevance to the records on the date of incident, and I said, and perhaps the day after, but now Ms. Schneider is pointing out that the state doesn't know he could have been treated a week later for something that happened on the date of the incident. Are you stipulating to relevance as to any injuries that the defendant sustained as a result of the incident on the video that was played today?
Judge, I will say that they may be relevant, which is why I'm asking for the in-camera inspection.
Okay.
And Judge, if I could just reply to
Sure.
one thing that Ms. Schneider said. I object to the characterization that we're developing the defense on the fly. The facts are as they are.
Okay.
My office did reach out to the captain of the facility, Captain Green at the time, to indicate that there was some friction between my client and Sergeant Beltran. Of the other 44 people on the ERT team, it was only Sergeant Beltran. So they had a plethora of people to choose from in terms of staffing. Whatever happened is for a jury to determine.
Okay.
We're not putting at issue we're not saying that his medical records are relevant to show that there's a history of prior mistreatment by this particular sergeant. There are other ways for the state to go about getting that. There is a kiosk that is located in the pod that inmates are required to use when submitting a complaint against a staff member. That is the only vehicle that they use, according to our depositions that we've taken, that they use to file a complaint to send it up the chain of command. We have that. The state has that. This could not be characterized as anything but a fishing expedition by the state judge.
Okay. Anything else?
No.
Mr. Wheeler, anything else?
That's all, Judge.
All right. I'm going to take the matter under advisement. I'm going to try to have a written order by Friday so that we can move forward with getting this case set for trial. And I think we should have the status next week so that depending on my ruling, you all can give me an idea of what will need to be done next. Of course, if I do decide to review the materials in camera prior to releasing them, I'm thinking because it's the sheriff's office, I can still get them rather quickly, I hope.
It's actually not the sheriff's office.
Oh, it's not?
No, it's the medical provider. And the medical provider has changed over time at the jail. I believe that the latest is WellPath? No, it was WellPath at the time. And now they're Complete Care Solutions or something like that.
They usually have a counsel, like a general counsel for the medical provider, don't they?
Possibly. They haven't raised any.
That might be the easiest way to go about getting them quickly, maybe.
Yeah, no, I mean, they can be, I've called the jail, the records are available.
Okay.
They can make copies and provide them.
So we don't have to wait 2 weeks for
No, we do not.
an income inspection?
We do not.
If I go that route?
Correct.
Okay. So why don't we do a status a week from today on the 21st? at 1:30,
Oh.
if that's, is that another day?
I'm not here next week.
Okay, okay, no problem.
Sorry.
So, let's do it on August 11th and the same day as the other days, if that's okay.
Okay.
Although, I think that was changed.
The 10th,
The 10th.
right.
Okay,
We
that's
changed
fine.
it yesterday to the 10th, that's somebody else, I don't know who, but, is it the 10th at 1:30? So we'll do it either right before or right after, does it matter? Do I need to, I guess because the lawyers are different, should I just say we'll do it at 3:30?
I'm on that
or 3
case
o'clock?
too, Judge. It's fine.
Yeah, it doesn't matter, Judge.
Okay, well, we'll set it for 3 o'clock, and then, if the other matter takes a bit longer, it might have to wait till 3:30 to address this case, but usually we can get things wrapped up on both cases. I think that would be easier for everybody, because if you're all gonna be here anyway, and then Mr. Cruz wants to come over, and the sheriff's office wants to bring them over on one day, okay?
Sure.
All right, thank you.
All right, thank you.
Judge, one thing while we're here.
Sure.
I was notified last week that my client is once again being supervised by Mr. Beltran. The court has previously said that's probably a bad idea for BSO to have that happen. I'm filing a motion for a stay-away order probably this week. So if we can be heard on that date, I don't want to take too much of the court's time, but I think it needs to be heard sooner rather than later.
Sure, and if you would please make sure to notice Mr.
Savanas?
Savanas. That's how you say it?
Yes, Savanas.
Savanas. Who I know very well, but I can never remember how to pronounce his name. I don't want to butcher it. So Mr. Savanas, please, if he can be here and he has time to look into it and maybe resolve the matter even without hearing.
Who would hope? Thanks, Judge.
Okay, thank you so much. We're in recess.